Many of my clients have become diligent about pursuing cyber squatters quickly, often very soon after a problematic domain name has been registered. And that's a smart practice because I've seen domain names used in some pretty dangerous ways right after registration. So the sooner a complaint is filed, the sooner an issue can be resolved or perhaps even avoided in the first place. But as one new decision makes clear, even some very old domain names are still worth pursuing. The case I'm referring to here was filed by Toyota Motor Sales USA under the UDRP, the Uniform Domain Name Dispute Resolution Policy, and it involved the domain name Toyota.com, which is identical to Toyota's own Toyota.com domain name, except that it contains two letter T's in the middle. And that slight difference is something that many internet users might not notice, and I suppose some people would actually type the domain name that way when looking for Toyota, either because they're unsure how to spell it correctly or because they simply make a typographical error. According to the UDRP decision, the domain name was offered for sale for $99,999, and it redirected to a website for Volvo cars. Here's the site I saw when I visited the Toyota.com domain name shortly after the decision was published. And while I don't know anything about this case other than what was reported in the decision, I suspect Volvo had nothing to do with this domain name, but instead, the registrant of the domain name was probably profiting by redirecting the domain name via some third-party affiliate program. Now, none of these issues is out of the ordinary, really. First, the extra letter in the domain name is just a common tactic used by cyber squatters and does nothing to avoid a finding of confusing similarity under the first element of the UDRP. In fact, the WIPO overview says a domain name which consists of a common, obvious, or intentional misspelling of a trademark is considered by panels to be confusingly similar to the relevant mark for purposes of the first element. And it specifically refers to the addition or interspersion of other terms or numbers as a type of confusing similarity. Second, offering the domain name for sale for a very high price is also not unusual. In fact, as I've talked about many times before, the UDRP specifically refers to offering a domain name for sale for valuable consideration in excess of documented out-of-pocket costs directly related to the domain name as one way that a trademark owner can establish bad faith. And third, redirecting the domain name to a website for a competitor, in this case Volvo, is also a common cyber squatting practice that amounts to bad faith, although the panel in this case actually didn't even address it, since it relied on the $99,999 offering to establish bad faith, something that the panel said was an amount wildly in excess of the possible out-of-pocket costs directly related to the domain name. But what makes this case unusual is when the domain name Toyota.com was registered. May 17th, 2004, more than 18 years before Toyota filed its UDRP complaint. Now, I have no way of knowing why Toyota waited so long, since the case doesn't include any explanation from the car company on that issue. In some UDRP cases, I've seen cyber squatters argue that a trademark owner's long delay in filing a UDRP complaint, sometimes referred to as latches, should somehow prevent it from obtaining a transfer of the domain name now, as if such legal action should be time-barred. But in the Toyota case, the cyber squatter didn't bother to file a response, so it obviously did not raise this issue as a possible defense. But still, the panel apparently couldn't help but comment on the lengthy delay. And here's what he wrote. The panel notes that the disputed domain name was created almost 20 years ago. A question has arisen in some UDRP proceedings as to whether lengthy delay in bringing administrative proceedings may somehow disentitle a complainant. It is now generally agreed that mere delay between the registration of a domain name and the filing of a complaint neither bars a complainant from filing such case, nor from potentially prevailing on the merits. Those cases where a complainant may have failed due to delay have been limited to their own particular circumstances, which find no parallel in this undefended case. And those particular circumstances to which the panel refers include such things as detrimental reliance, which arguably could occur where a domain name registrant might be able to show that it actually relied on the fact that it had the right to use a domain name because the trademark owner failed to assert its rights. But that situation rarely arises. Instead, the Toyota decision, which specifically said that latches did not apply, is consistent with the WIPO overview, which says the following. Panels have noted that trademark owners cannot reasonably be expected to permanently monitor for every instance of potential trademark abuse, nor to instantaneously enforce each such instance they may become aware of, particularly when cyber squatters face almost no financial or practical barriers to undertaking multiple domain name registrations. So, 18 years later, Toyota got an important domain name. While its delay did not have any impact on the outcome of the case, it's impossible to know how much damage it incurred in the meantime, which is a good reminder that taking on cyber squatters sooner rather than later is usually the best approach. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.